quick introductions. My name is Jessica Vargas. I'm the Chief Marketing and Communications Officer here at the Paid Leave Authority, and I'm joined by my colleague, Kathy. Kathy, do you want to introduce yourself?
Sure. Good afternoon, everyone. My name is Kathy Mihailuk, and I'm the Benefits Process Lead here at Connecticut Paid Leave Authority. And I look forward to presenting to the group this afternoon the presentation that Jessica has put together. Thank you.
All right, let me share my screen and we will get started. Okay. Kathy, can you see my screen okay?
Yes.
Great, thank you. All right, well, thank you for joining us today. Our presentation today is called The Small Business Owner's Guide to Paid Leave, and we are going to talk about not only the Connecticut Paid Leave Act, the implementation of the program, what are the reasons folks can apply, but also some changes that have just gone into effect for family and medical leave and how those might impact your business. So we'll talk about, as I said, the program, the differences between FMLA and what we refer to as CTPL, Connecticut Paid Leave, the implementation of both, and we'll leave you with some additional resources, both on the Connecticut Paid Leave side and on the FMLA side. Just as sort of a precursor to this conversation, we are providing information about FMLA, but that falls under the purview of the Department of Labor. So any further questions that you might have after this presentation or documents, forms, etc., we will show you where to find those on the Department of Labor website. And of course, as Amber mentioned, we will have some time for Q&A at the end of this presentation. So first, just want to give you a brief overview of the Connecticut Paid Leave Authority. So the authority is the quasi-public agency that oversees the Connecticut Paid Leave program. And we have 5 sort of main areas of focus. The first being outreach and engagement. So ensuring that everyone who's touched by this program, whether it be employers, employees, human resources professionals, third-party administrators and payroll providers, that they understand what their role is in the program. We develop the policies and procedures needed to run the program. We establish the trust fund contribution rate and receive contributions. We approve and audit private plans. That is for organizations who would like to choose a separate plan in order to provide this benefit to their employees as opposed to participating in the public plan. And we administer claims for paid leave benefits together with our chosen third-party provider, which is AFLAC. Some key dates to sort of orient yourself as to where we are in the the timeline of this program. Registration for employers opened in November of 2020. January 1st of 2021 is when employers were to begin deducting worker contributions. So this program is entirely worker funded through a payroll deduction of 1/2 of 1%. That 1/2 of 1% is set by the statute. So as I mentioned previously, where I said establish the trust fund contribution rate, we cannot increase it, we can decrease it, but that 1/2 of 1% was set by the statute. So at this point, employers should have been taking deductions from their employees for the past year. And those deductions are remitted to us here at the Paid Leave Authority quarterly. There is a 30-day grace period after the end of the quarter. So for example, first quarter contributions were due by April 30th. Where we are right now, fourth quarter contributions for fourth quarter 2021, which just ended, will be due by the end of January 2022. Starting in December, workers were able to begin applying for events that they knew would be happening in January or beyond. And starting on January 1st, any approved applications were eligible to begin receiving benefits. Also of note, just want to make sure I mention this, that the Connecticut Department of Labor has authorized what we call a catch-up period, which runs now through March 31st, 2022. And what that means is if an employer missed taking some deductions last year, the Department of Labor has authorized them to be able to take an additional 1% just in these next couple of months in order to make up for those missed deductions. So they can take 1% in addition to the statutory 0.5% for a total of 1.5%. But again, that is only through March 31st of 2022. After that, the deduction would have to revert to the 0.5%. let's talk about who is covered by the Connecticut Paid Leave Program and who is not covered. So as far as who is covered, employers who have one or more people working in Connecticut are required to participate in this program. And that does include nonprofits as well as private sector employers with a unionized workforce. Now, individuals who are self-employed or sole proprietors may choose to participate in the program if they wish, but it is not a requirement for them. If they do choose to opt into the program, the only caveat is that they must remain in the program for a minimum of 3 years. As far as exclusion, so folks who would not be covered by the Connecticut Paid Leave Program would be employees of the federal government, employees of the state of Connecticut, except as to covered public employees, which I'll address in just a moment. The same goes for municipalities and local or regional boards of ed. They are not covered unless they have covered public employees. And employees of non-public elementary or secondary schools are not covered. Then there are also a few other categories that are excluded as the result of other laws that cover them. And that includes railroad workers, people who are employed by the government of another state, employees of the sovereign nations, which of course here in Connecticut, we have Foxwoods and Mohegan Sun, so their employees would be exempt. Employees engaged in interstate commerce, so that would be your truck driving profession, and spouses of active duty military if they have opted to continue to pay taxes in their home state instead of in Connecticut. Now, in a couple of those categories, I mentioned covered public employees. So what does that mean? Non-unionized employees of the state of Connecticut are considered covered public employees, and so they are participating in this program. Unionized employees of the state who collectively bargain to be included would also be covered. Employees of municipalities and local or regional boards of education, again, if the unionized employees collectively bargain to be included, then all employees, both union and non-union, would be covered by the program. And you can see down there at the bottom of the slide the definition of municipality, which we put just to show that it is a very broad definition. It includes cities and towns like you would normally think, but also things like tourism districts, housing authorities, etc. Now, I mentioned sole proprietors and self-employed individuals. They may choose to opt into the program if they would like to, but they are not required to by law. However, if someone pays self-employment taxes as defined by the IRS, then they are not an employee. They are not required to participate in the program, but they can choose to enroll if they would like to. I mentioned they would have to stay enrolled for at least 3 years, and they would contribute at the same rate as everyone else, so half of 1% of their self-employment earnings. Now, if there's a sole proprietor who also has employees, even if they choose not to participate in the program for themselves, they must register their business with Connecticut Paid Leave and deduct those contributions from their employees and remit them quarterly. If you receive a W-2, you are considered to be an employee under the law and you must participate. And this is true even if you are the owner or an officer of the company. Now, you've heard me mention the contributions are 1/2 of 1% of wages. They are post-tax and they're calculated based on the wages as used for FICA contributions. The contributions are capped at the Social Security limit, which most recently was $142,800. I know it is increasing to $147,000. So the maximum contribution amount is capped at that rate. So even if someone earns, say, $200,000 or $250,000, they would not contribute more than the 0.5% based on that Social Security maximum. Employers take those deductions from worker paychecks and they remit them to us quarterly through our online portal at ctpaidleave.org. We receive those contributions and we validate that they are accurate based on information we have from other state agencies. We deposit them into the Paid Leave Trust Fund, and the Paid Leave Trust Fund is the source from which benefits are now being paid for approved claims. So now we'll get into FMLA, which stands for the Family and Medical Leave Act, and how it is similar to and different from Connecticut Paid Leave. So FMLA provides job protection, and FMLA has been around for nearly 30 years. There's both a federal law and a state of Connecticut law. And as I mentioned, these laws allow people to take job protected time away from work for certain qualifying reasons. However, they do not provide any sort of income replacement for that time away from work. So it's unpaid leave. Some employers do provide paid leave. So for example, one of the most common things is probably paid maternity leave, but it's not ever been a requirement under FMLA. Many employers will also require or permit their employees to use their accruals, so their sick leave, their PTO, vacation time, etc. Connecticut FMLA has just undergone some pretty substantial changes, which went into effect on January 1st of this year. And so we want to make sure that you're aware of these because they are impacting almost every business in Connecticut. So probably the biggest change with Connecticut FMLA is that it previously applied to businesses with 75 or more employees, and it now applies to businesses with 1 or more employees. So many businesses in our state who have never had to consider job protection under Connecticut FMLA now do have to look at that when an employee tells them that they're taking time off of work for these certain qualifying reasons. Other big changes are that there is no longer an hours worked requirement for eligibility. It used to be 1,000 hours in the past 12 months. There is now no minimum hours worked requirement. Additionally, a person would be eligible for job protection after 3 months of employment instead of 12 months, as the law had previously stated. There are also some expanded reasons for leave, which includes family violence leave, and there's an expanded definition of who is considered family, which we'll talk about. This just shows you a side-by-side comparison of what I just talked through. So again, most importantly, now 1 or more employees, you must consider FMLA and job protection if someone is taking time off. That job protection would attach after 3 months of employment with no minimum hours worked. And the time frame or the time allotment for job protection under FMLA has also changed. So it used to be 16 weeks of leave in a 24-month period. It is now up to 12 weeks of leave in a 12-month period for all leave reasons. There had previously been, and there remains still to be 26 weeks of leave for military caregiver leave. Something new is that there is an additional 2 weeks of leave potentially available for incapacitation during pregnancy. Another significant change is that previously an employer could require their employee to use all of their accrued PTO in order to receive any sort of income during their leave. But now, starting in 2022, the employer has to allow them to retain up to 2 weeks of their accrued PTO. So for example, if an employee is going out to have a surgery, you establish that it is eligible for job protection under FMLA, and that employee has 4 weeks of PTO and their doctor says they will need to be out for 4 weeks for recovery. You cannot require them to use all 4 weeks of their PTO in order to be paid. You can require them to use 2 weeks, but you have to allow them to retain the other 2 weeks for future use if they would like to. If the employee decides they want to use all of their time, that's completely fine, but you cannot compel them to use all of their time. You have to let them retain those 2 weeks. Now, Connecticut paid leave is almost sort of the flip side to FMLA, if you will. So it does not provide job protection, but it does provide income replacement. You'll hear us use the acronym CTPL, and we use it to refer to the statute itself, the program, and also ourselves here at the Paid Leave Authority. The law created a source of income replacement benefits for folks who are taking time off for these certain family and medical reasons, which we'll review momentarily. But again, it does not provide job protected leave. So there are instances in which a person could be eligible for Connecticut paid leave benefits, but not job protection under FMLA. What are the reasons that someone can apply for, you'll see it says leave and or receive benefits, because these reasons do apply both to job protection under FMLA and benefits under Connecticut paid leave. The first reason is medical leave. So medical leave is leave that an employee takes to receive treatment for or recover from their own serious health condition. This does include serving as an organ or bone marrow donor, and pregnancy is also considered a serious health condition. The second reason is called bonding leave. Bonding leave is leave that an employee takes to bond with a new child that has entered their home through either birth, adoption, or foster care. Both mothers and fathers can take bonding leave, and it can be taken at any time in the 12 months immediately following the child's birth or placement in the home, if it's in the case of adoption or foster care. Additionally, with adoption or foster care, this leave can be used to attend to pre-placement activities. The third type of leave is caregiver leave. And caregiver leave is leave that an employee would take to provide care or comfort for a family member who is experiencing a serious health condition. As I mentioned, Connecticut has a provision for family violence leave. So family violence leave would be taken by an employee who is experiencing family violence, and the reasons for using that could be obtaining services from a victim services organization, seeking medical or psychological care or counseling, relocating, or attending criminal proceedings. With family violence leave, there are up to 12 days of the 12 weeks available for use in a calendar year. And then the last two types of leave pertain specifically to the military. One is called qualifying exigency leave, and that is leave that a worker can take if they are notified that their spouse, child, or parent has been notified of an impending call to federal active duty. So for example, if a spouse learns that they're going to be deployed, the worker might need to take time off to do things like make alternative childcare arrangements or see their attorney to work out details for their will or something like that before the military spouse is deployed. And then the last is called military caregiver leave, and that is leave that an employee would take to care for a military family member who is injured in the line of active duty in the armed forces. Now, we added a special slide in here just because, given the current circumstances, we've been getting a lot of questions about paid leave and COVID, and if someone can apply for paid leave benefits if they are diagnosed with or exposed to COVID. And so the answer is that simply being exposed to or diagnosed with COVID is not in and of itself considered a serious health condition. So simply being diagnosed does not mean that someone can apply for paid leave benefits. However, if the person can provide medical documentation establishing that this diagnosis or exposure meets one or more of the elements of a serious health condition, then they could potentially be eligible for benefits. And so here are some of the different things that would define that serious health condition. If they required an overnight stay in a hospital or other medical care facility, if they were incapacitated, either themselves or if they're applying for caregiver leave, their family member, so they were unable to attend work or school for more than 3 consecutive days, and that included ongoing medical treatment, or that the diagnosis or exposure to COVID resulted in or exacerbated a chronic health condition that causes occasional periods of time where the employee or their family member is incapacitated, which requires treatment by a healthcare provider at least twice per year. Now, on the topic of caregiver leave, we mentioned that that is leave that can be taken to care for a family member. And under the Connecticut law, here's what the definition of a family member looks like. It's any of these relationships that you see listed: parent, son, a daughter of any age, spouse, sibling, grandparent, grandchild. But there's also this definition of relationship by affinity. So an individual related to the employee by blood or affinity, whose close association they can show to be the equivalent of one of the family relationships listed. So what does that really mean? That means that someone can take time off of work to care for a family member who's experiencing a serious health condition, even if they are not biologically or legally related to that person, if they can show this relationship by affinity. So, for example, if there's an uncle or an aunt who relies on the employee for unpaid care and they have a relationship as similar to the one that you would normally see between a parent and a child, that could be considered relationship by affinity. A common example might be an unmarried couple. Perhaps they share a home, they have children together, but they are not legally married, even though they maintain this familial spouse-like relationship. This would also be considered relationship by affinity. And so in these circumstances, an employee could apply for paid leave benefits to take time off to care for these people, even though they are not legally related to each other. Now let's take a look at the summary of eligibility requirements. And we have in here not only Connecticut FMLA and Connecticut paid leave, but also federal FMLA. So if your business has 50 or more employees, you are also covered by federal FMLA. There are no changes that are going into effect or have recently gone into effect. So this is just for your information as we're looking at all this in context. Federal FMLA provides job protection for someone who has been employed for at least 12 months and who has worked at least 1,250 hours. Connecticut FMLA, under the new law that just went into effect 2 weeks ago, covers someone for job protection when they have been employed for at least 3 months with no hours worked requirement. And now the eligibility for someone to receive Connecticut paid leave benefits is as follows. There is a minimum earning requirement, so at least $2,325 in the highest earning quarter of the first 4 of the 5 most recently completed quarters. That can come from more than one employer. So if a person works, say 2 or 3 part-time jobs, as long as their total wages were $23.25 or more in that base period, they would be eligible under that minimum earnings requirement. And then the other requirement is either that they are currently employed and working in Connecticut, or if they're unemployed, that they had been working in Connecticut with a covered employer in the 12 weeks immediately preceding their leave. And again, sole proprietors or self-employed individuals must have opted into the program. And for those folks only, there is a residency requirement. So sole proprietors do have to be residents of Connecticut as well. Now we'll just look at the summary of entitlements side by side. So federal FMLA and Connecticut FMLA both provide up to 12 weeks of job protection in a 12-month period for all leave reasons. The only exception is military caregiver leave, in which case both federal and state provide up to 26 weeks in a 12-month period. Additionally, in Connecticut, up to 12 days in a calendar year may be used for family violence leave. And an employee could potentially receive an additional 2 weeks of job protection for incapacitation during pregnancy. Now, benefits under Connecticut paid leave. Just like with FMLA, there are up to 12 weeks in a 12-month period available for all leave reasons. One thing here that's a little bit different is that military caregiver leave is also 12 weeks in a 12-month period for income replacement benefits. So if someone is taking military caregiver leave, they could potentially be out for 26 weeks and have job protection, but only 12 of those weeks would be eligible for income replacement under Connecticut paid leave. We also do provide up to 12 days of income replacement for family violence and those additional 2 weeks of income replacement for incapacity during pregnancy. So now at this point, I'm going to turn it over to my colleague, Kathy, and she's going to talk about the implementation of Connecticut paid leave.
Thank you, Jessica. Hi, everyone. What we're going to do is go through the different processes, the different steps for the worker, employer, Connecticut paid leave, and what the responsibilities are for each of those sections. First of all, excuse me, when a worker knows that they're going to go out on leave, they need to, first of all, submit their application timely. And how they do that is they go to the Connecticut paid leave site, they create an account, and in addition to creating an account, there is a separate button where if they wanted to file their claim right away, they would do so through the AFLAC portal, which is visible, excuse me, once they have registered their account. So the steps are, they need to notify the employer, create a CTPL account, and make sure they file a claim on the AFLAC portal. For the employer, there is a form that the employee will be giving the employer called an employment verification form. And what it does is it validates sources of income, such as, are there any PTO days that will be paid while this person is out? Are there short-term disability policies? Does the company have a short-term disability policy that they'll be using? And this is the kind of information that we would be looking for from the employer to provide. Now, the one thing I just want to mention about short-term disability policies, I would highly suggest that you review your plan document to determine whether short-term disability is primary or secondary to Connecticut paid leave. Depending on how your policy is written, it's in the what I call the fine print of the plan document. So it would be very important for employers to review that information to better prepare themselves to administer the Connecticut Paid Leave Program. So once the employer has completed and submitted the required documentation, the Connecticut Paid Leave Authority through AFLAC would determine the eligibility, make sure that the appropriate documentation has been provided. They calculate the benefits. They monitor ongoing claims, assess requests for reconsideration. What reconsideration means, an employee has 30 days prior to their leave to start the leave process, which is create an account, register, file a claim, go to your doctor, get the necessary medical certification. If for some reason the claim is denied, there is an opportunity for reconsideration. For example, perhaps a physician, they weren't able to get the medical documentation on time, or they weren't able to get the employment verification form, excuse me, completed on time. So there is a reconsideration form, excuse me, that appears in the employee's file in their Connecticut, in their AFLAC account. Excuse me, I'm just getting over a cold, so I apologize. So if there are any additional forms that the employee needs to complete or any updates regarding their claim, an employee can log on to their AFLAC account, and any items missing or any additional requests made by AFLAC to the employee would be found in that site. If there are, if someone completes a reconsideration and it's still denied through the Connecticut Department of Labor, and a person can file what's called an appeal, because they want to appeal the denial for their claim because maybe they have additional information that wasn't provided additionally. And this is just another process to go through if an employee was interested in appealing their denial for their claim. So once again, the income replacement benefits process. The worker submits a claim. They go to Connecticut Paid Leave. They set up an account. Then there's a button that comes up. Do you want to file your claim at this time? They can file at a later date, but it's usually easier for employees to file that claim right after they've registered. And excuse me, on that site, there will be a checklist where here's a list of items that the employee needs to provide. And also, once the employee gets the supporting documentation, let's say from their healthcare provider or whatever documentation they have, they could download that onto the site, right onto the AFLAC site. So once AFLAC receives all the required documentation, they go through an eligibility process. AFLAC does go to the DOL data. They have access to this information to validate that the worker is working for a covered employer or is registered as a sole proprietor. If it is determined that the worker is not eligible, AFLAC would also notify the worker and offer the right to request reconsideration. AFLAC then determines if the claim is approved. They review the supporting documentation, such as the employment verification form and the physician's medical certification. If there is any information missing, AFLAC will notify the worker. If the claim is denied, AFLAC will notify the worker and offer the right to request reconsideration. So just as a footnote, AFLAC does keep in contact with the worker as to the steps in the process, anything that's missing, or additional information required. Excuse me. Next, AFLAC calculates the benefits. They use the Department of Labor data and other sources of information necessary to calculate the base weekly earnings. So it's very important for employers to complete that employment verification form to verify the hours an employee works, and other questions are on the form, such as, has the employee applied for workers' compensation? Are they collecting unemployment benefits? If the employee is on workers' comp or has applied for unemployment, let's say for some reason, they're not working at the company anymore, they would not be eligible for Connecticut paid leave. So it's important to have all that information and to fill out the employment verification form as completely as possible. AFLAC issues the benefit payments. Once they go through all the paperwork and have determined eligibility and a claim is approved, benefits will be issued on Tuesdays. Employees have the option of direct deposit or what's called a stored value card, which is like a debit card. And the benefits are issued every Tuesday and paid in arrears. So for example, a benefit of this week from 110 to 114, if someone was approved and eligible, the payment would be issued on January 25th. It is the worker's responsibility to notify AFLAC of any changes. For example, let's say someone applied for leave and the start date has changed or the end date has changed. They would have to notify AFLAC and receive other documentation from the physician. So let's say they were approved for one period of time to be out of work, and now they're healing and they're recovering faster than possible. Now they want to come back to work, they would have to get another note from the physician saying that they were able to return. If the worker is taking intermittent leave, they also would need, thanks Jessica, if there's any changes in their intermittent leave schedule, they need to provide frequent updates to AFLAC about that particular leave. Here is an example of the Connecticut paid leave employment verification form. So what I would like to do is just go over the employer information section because a couple things have changed as far as processes. Now we would need the employer name because we need to know who the employee works for. There are 3 questions for tax or ID information: the federal employer identification number, a tax ID, and then a SIC/NAICS code. You're only required to complete the FEIN number. Originally, we needed the additional information to locate employers, but we have found that by providing only the FEIN number, we're able to find employer information rather quickly. Complete the address of the company, the contact name, which would probably be someone like yourselves that if there were any questions regarding hours or for some reason AFLAC had to reach out to the employer, we would have a contact person's name, email, and phone number. It is very important to have the email section completed. Once an employee is approved for their claim, not only is the employee notified, but an email is sent to the employer. So the email is the most efficient way to get information to employers. It could be sent United States Postal Service. However, that could take some time before that information is received in your office. As we go through the form, things like the employee's date of hire, job title, date the employee last worked. Sometimes if it's an emergency situation, you're looking back. But if the employee has a scheduled leave, say for surgery in the future, you can put down, an estimated date as to their date last worked with the first date that they plan on being out on their leave. We ask for hours for 12 weeks prior to when the person's going out. If this was an injury on the job, has the person applied for or is receiving workers' comp? Just because someone is not receiving workers' comp doesn't mean they haven't applied and that the claim is in process. We need the employer to sign the form. We will accept electronic signatures from the employer. Benefit calculations. Let's say a minimum wage worker receives 95% of their base weekly earnings. Those earning above minimum wage have a slightly different calculation. Maximum weekly benefits are capped at 60 times the state minimum wage. So the state minimum wage is currently $13 an hour, times 60 is $780. That is the most amount of benefit that any person could receive. Please keep in mind when we're looking at PTO, short-term disability, and CTPL benefits, a worker may and will never receive more than 100% of their normal wages. If there is an error, and let's say at some point the worker does receive more because of timing issues, or we didn't know that the person had PTO time, we do have an overpayment process in place. And the goal is, of course, never to have anyone receive more than 100% of their normal income. Okay, this is a snapshot of what is on the Connecticut Paid Leave site. There is a benefits estimator at connecticutpaidleave.org. And you can see here under the estimator, it says select the pay frequency. So it's weekly, monthly. I believe there's an annual option also. Please enter your gross earnings. And then, oh, there it is, weekly, quarterly, annual. You can estimate and have an idea as to what the worker would be receiving for their benefits. Okay, so here are a few examples we're going to go through just to help you familiarize yourself with the process a little more. Scenario 1, the worker has no PTO time to use for FMLA. So the worker has no PTO, they would receive the full, let's say they were approved and they're getting the $780 a week, they would receive the full amount of Connecticut Paid Leave benefits for the full period of the leave. Scenario number 2, a worker has enough PTO to cover the entire leave. So no CTL benefits would be paid. So if let's say the worker is going out for 12 weeks of leave, for some reason they have 12 weeks of PTO, depending on the company and depending on the policies. I've seen it everywhere from companies offering 1 week of PTO to a 12-week program. So if an employee is already being covered by an employer PTO program, there would be no CTPL benefits paid to the worker. Okay. Scenario number 3, the worker has paid time off to cover part of their leave. So the Connecticut Paid Leave benefits would start after the employer, the PTO benefits from the employer have been exhausted. And under Connecticut FMLA, minus the 2 weeks employees are entitled to keep. And that's Connecticut FMLA, which these examples are Connecticut paid leave. So that's the difference. Scenario 4, paid time off pays less than workers' regular pay. So let's say the worker gets benefits at the start of the leave and Connecticut Paid Leave pays the benefits. Employers can coordinate the benefits to make up any wage differences. Keep in mind, the goal employees are not to receive more than 100% of their regular pay. What do your workers need to know? So they'll be coming to you for questions, and they're going to ask them if they have any paid time. They're going to ask you if they have any paid time off, or what is the absence management policy for your small business? Are they going to get paid any paid time off from their employer? So rules such as, is there any sick time that they can use during, going out on leave? Is there any vacation time? What are the rules of the company? What are the policies? If the company offers a short-term disability policy, things to look for are items such as, does the worker have to exhaust all their PTO and Connecticut paid leave before the short-term disability benefits begin? And as I had mentioned earlier, it's very important to look at your short-term disability policy for these differences. Will the short-term disability policy reduce the amount, or will it start after all other benefits are exhausted? So these 2 points of clarification you'll need to find by looking at your short-term disability plan document and policy. Okay, responsibilities for Connecticut FMLA claims. Now, again, as Jessica had mentioned earlier, we are providing information about Connecticut FMLA. However, Connecticut FMLA is administered by the Department of Labor. So again, the worker notifies the employer that they need to take time away from work. We always like to encourage employees and workers when they go out on a leave to be in contact with their employer and provide information, have an open dialogue as to, I need to take a leave and here are the dates, and they're going to come to you with questions as to what do I need to do. So they would submit an application. The CT FMLA documentation is also on the DLWell website. So if you need those documents, you can print those off the site and keep copies, in your files or on your hard drive or wherever. The employer has to have established leave policies, including rules about PTO usage. If your company does not have these rules in place right now, it's going to be very difficult for you to administer the CTPL, FMLA, and the CT-FMLA claims. So if you don't have an established policy, I highly recommend that you work with legal or whatever departments, whatever departments at your employer handle this. You need to get something documented so that it's consistent and it's established as to what employees need to do. You need to monitor the leave request, manage when the worker returns to work. Sometimes they come back earlier than they anticipated, and sometimes they need to stay out longer. So those things need to be managed due to the business needs. Again, Connecticut Paid Leave has no Connecticut Paid Leave Authority has no official responsibilities to Connecticut FMLA, but we do provide this information as part of our training. The Connecticut Department of Labor has regulations surrounding Connecticut FMLA, and they do provide guidance to workers and employers about the process and about Connecticut FMLA altogether. Again, if there are any complaints regarding denial of Connecticut FMLA claims, then the Department of Labor, Connecticut Department of Labor, would investigate these complaints. Job Protected Leave Process, FMLA. Workers notify the employer they need to take time off from work, and the worker is not required by law to use the term FMLA. So an employee may just come in your office and say, I'm having surgery and I need time off from work. Ideally, 30 days in advance is if the need is foreseeable. And a lot of times, not that many, but I have seen instances where as soon as practical for a leave that's not foreseeable, such in a case of an emergency, for example, like a car accident or something, you may not find out until days later that something happened to this particular employee. The employer determines if the worker is eligible for Connecticut FMLA and notifies the worker if they need to provide any additional documents. The employer has 5 business days to notify the worker of eligibility and provide a notice which is called the rights and responsibilities. Please note that this is not the leave approval. These are requirements in handling the Connecticut FMLA process. So the worker provides the required documentation. Let's say they go to their physician, their healthcare provider, they get the medical certification, adoption documents, military records, whatever documentation is required depending on the leave. The worker has 15 days to provide that documentation. If the worker has difficulty obtaining these documents, they should notify the employer, and the employer should give the worker additional time. The employer notifies the worker if the leave is approved under Connecticut FMLA. So the employer has 5 business days once it receives the required documentation to support the leave request. The employer notifies the worker if they're required to use paid leave accruals, how and when the worker needs to report in, and if the worker will need a fitness for duty before returning to work. The worker reports to the employer when they actually take the leave. The employer's responsibility is to track the leave usage to ensure that the worker does not go over the 12-week period. The employer returns the worker to the job that they held before the leave. The worker has the right to return to the same job with the same terms and conditions. An employer cannot insist that an employee be 100% fit for duty or totally recovered, because the employer must also consider ADA and CFEPA obligations. Workers who don't want leave to be designated as family medical leave. In all circumstances, it is the employer's right and responsibility to designate time off that qualifies under FMLA leave as FMLA leave, even if the worker did not ask for it. This protects you, the employer, and your employee. Overview of leave laws. Laws providing job-protected leave. Federal FMLA applies to employers with 50+ employees. Connecticut FMLA, before 1/1/22, applied to employers with 75 or more employees. Effective 1/1/22 applies to employers with at least one or more employees. Workers' comp covered on-the-job injury and illnesses. Americans with Disabilities Act, 15 or more employees. Pregnancy Disability Act, 15 or more employees. Connecticut Fair Employment Practice, 3 or more employees. Laws providing income replacement during leave. Connecticut Paid Leave Act, 1 or more employees working in Connecticut, effective 1/1/22. And there's workers' compensation for covered on-the-job illnesses or injuries.
Thank you very much, Kathy. So now we just want to leave you with some additional resources where you can find more information. Our website is a great source of information. It's ctpaidleave.org, and we have several downloadable resources to help you both administer the program and learn more about it, and also that you can print out to provide to your employees. So we have an employee rights poster that you can post in your office. We have an employee rack card. We have a paycheck insert, and all of these have just been updated. So when you go to our website, you should see the most recent versions. We have an employer toolkit and a human resources toolkit to help you administer the program. And as we've mentioned, the Department of Labor is the one who provides all the information in regards to FMLA. So this website that I've highlighted right here, portal.ct.gov /DOLUI/new FMLA guidance. That's where you can find all of the forms, notices, etc. for FMLA. And I just put a couple of copies in here just so you can see those are downloadable, they're linked. So that's where you can go to get that information. We know this is a new program. We know that there are probably a lot of questions around it. So we are here to help. While we do not have a call center, we do have a Contact Us portal that you can access through our website at ctpaidleave.org. You just go to the Contact Us tab, put in your information and your question. And if you would prefer to speak with someone instead of communicating through email, we can accommodate that. We would just ask that you indicate that in your submission, and then someone from our customer support team will call you back. We also have several hundred frequently asked questions on our website, and we have some helpful videos, some of which you can watch directly through our website. But if you visit our YouTube page, we also have many other videos there, including tutorials about how workers can create an account with Connecticut Paid Leave. We have a tutorial video that walks them through the process of submitting a claim with Connecticut Paid Leave. So we would definitely advise that you check that out. And with that, I will stop sharing, and Kathy and I would be happy to answer any questions. I see a couple people have used the chat. Oh, actually, one person used the chat, and then Amber put the answers in there. So thank you very much, Amber. So we do have a couple more minutes. If you have any other questions that Kathy or I can answer for you, please do use the Q&A feature and put them in there.
Don't be scared.
Jessica and Kathy, maybe now might be a good opportunity to share the other webinar opportunities that we're offering right now.
Sure. So we have sort of 3 different categories of webinars that we're hosting. This one for small business owners. We also have one for workers. So if you have any employees who have come to you and indicated that they might need to take some time off, you could direct them to attend one of those webinars. And then we also have a webinar for folks who are more on the human resources and benefits side. And then lastly, starting in the middle to end of February, we'll have some updates on our claims administration for anyone who is interested to see how many claims we've processed and what categories they fall into. And you can find all of those different topics, dates, and times on our website on the events page at ctpaidleave.org. And from there, you would just click into the particular event that you would like to attend, and you can do your Zoom registration right there. So we have a quiet group today. Thank you so much for your time. As Amber mentioned, this is being recorded and she'll send out the link to you in a few days, as well as a copy of the deck for you to refer back to. Please do reach out to us through the Contact Us portal with any questions or anything that we can help with. Thank you so much. Thank you, Kathy. Thank you, Amber.
All right. Thanks, everyone.